The further records required is also a register of the shareholders as well as a register of the beneficial owners. So beneficial ownership, for those who are not acquainted with the term, it simply speaks to third-party ownership or external ownership where you have someone representing you, whether it's an entity, a trust, or another company that represents your interest or shares in a company. So the essence there is really to get or trace the real owners of a certain company. As far as our financial intelligence requirements are concerned. Next, we have a requirement on accounting records. We've discussed this already, but what really is highlighted is requiring that companies maintain accurate accounting records and also penalizing falsification of accounting records and the publishing of false financial statements. Now, there was a proposal in our consultations as regards to intention, and the proposal was simply just to penalize the failure to submit accurate or correct financial statements as opposed to attaching an intention requirement to your failure to submit. If that's clear for the floor to understand. Shall I pause? No? Okay. The theme is quite long. Okay, I'll continue to the transparency requirements in respect of annual returns. Obviously, the procedure now already is that you should submit your annual returns, but the proposal is that you pay your annual duties whether or not you file an annual return. And in addition to submitting an annual return, there's a requirement that you submit annual financial statements as well, whether you're an exempt company or not. Now, in section 14 of the Act, an exempt company will be a company that's restricted by its board from providing certain information, or a company that has applied to BIPA to exclude certain information from their disclosure. Put on to that is the requirement of the disclosure statement by your accounting officers or your auditors. So essentially speaking to a statement that allows your accountants to have access to your information as a recipient of your confidential company records. And then the last requirement as far as enhanced transparency requirements is obviously something that we're posing to the floor, to the constituency to say, look, we acknowledge that we need more enhanced transparency as far as public companies are concerned. So the question really is, what is the proposal from the stakeholders as to what those enhanced transparency requirements should be, especially with regards to SOEs? The proposal in respect of the imposition of transparency and accountability requirements is that it should apply to all companies across the board. Whether it's public companies, whether it's your state-owned companies, private companies, Section 21 non-profit companies. But in addition to that, the requirement is also that companies should have company secretaries, they should have auditors, and BIPA should have access to the information that is populated by your auditors and your secretaries. And then the last point on legal backing of financial reporting standards. So of course we've established already that there's a requirement for companies to provide accounting records. So then comes the issue of enforcement and who is then responsible to ensure that companies are indeed complying with the statutory requirement provided for in the Act to provide, to number one, maintain accounting records and then also disclose them. So ordinarily this would be a responsibility for BIPA, because BIPA is responsible obviously for setting standards and they're responsible for adopting standards, implementing standards, and monitoring the compliance, the compliance from their members of these standards. So then the requirement is that financial reports from companies should comply with this accepted standard or regulated standard by the proposed council. So the responsibility of the council would then be, as was already mentioned in the room or suggested, that the standards would be reviewed annually or biannually by this council at set in place. But the law would then provide that there should be a council that would then review and regulate the standards that should apply to our companies. That concludes in three. How about swift enough?
Yes, you're welcome. All right. So my question was around the requirements of the board minutes. Is it an expectation now that we're defining our board minutes and resolutions with BIPA, or what are the changes around that area? And the reason why I'm asking is obviously board minutes are highly sensitive and highly confidential, and they're also highly competitive. It's not something that we want to talk anywhere.
Evelina, it is, you are correct in saying that board minutes, I suppose, are confidential and they contain confidential information. The requirement is for you to keep them, and we have the rights to request them on demand. And then, as you normally do, if they are sensitive information, you can also break that out, and the relevant ones will. But the resolutions that have a direct impact on whatever changes we need to make, you have to file it with us. But these are things that we can talk to and see how to better phrase it in the regulations of the law.